everybody. Hello, everybody. We continue with the Indian Partnership Act 1932, and I am Dr. G. Mallikarjun. So today, we'll be talking about Chapter 4 of the Partnership Act, which deals with the relation of partners to third parties. This has sections from Section 18 to Section 30, and three important aspects are there in this chapter. One is about implied authority of partners to bind the firm by their actions. The second thing is holding out. Third important aspect is relating to minor admitted to the benefits of partnership. So these three are very important areas here. So the section 18 talks about partner being the agent of the firm. Then section 19, 20, and 21 talk about implied authority of the partner to act as an agent. Then what are the instances where the implied authority cannot be deemed? Then extension or restriction of the implied authority of a partner by the contract or an agreement of partnership. Then authority of the partner in an emergency. So these three sections deal with the implied authority along with section 18. It will be completed. Then section 22 talks about mode of doing act to bind the firm. So here, if you're doing something in the name of the firm and in the normal course of business, you will be binding the firm for that particular act. That is section 22. Then effect of admission by partner. Then section 24 talks about effect of notice to a partner, to acting partner. That will be sufficient as far as the whole partnership is concerned. Then section 25, 26, and 27 deal with liability of partners for acts of the firm, liability of the firm for wrongful acts of a partner, and liability of the firm for misapplication of by the partners. So these are aspects of liability. Then section 28 is a very important section which talks about the doctrine of holding out or the principle of holding out. Section 29 talks about rights of transfer of partners' interest. Then section 30 is a very important section which is a complete code as far as minors admitted into the partnership for the benefit. Then what happens after it becomes major? Then what are the liabilities, etc. So that is, these are the sections that are covered. So the relation of partners to third parties, the most essential aspect of it is this principle which comes out as mutual agency. So here, partner to be the agent of the firm, then implied authority of the partner as agent. Here we understand what is the implied authority. Then the section itself provides that implied authority, except specified by contract, cannot be deemed to be there for the following aspects. So there are certain aspects which are listed out. So these are statutory restrictions. Then through agreement, again, the partners themselves can modify this. These are called as contractual restrictions. So extending or restricting the implied authority can be done through the agreement. But will that be effective and what will be the effect is something which will be covered in section 20. Then section 21 talks about authority in emergency. So if someone does something in emergency, which in the normal circumstances he would do for himself, acting for himself, then that will bind the firm. Then mode of doing an act to bind the firm. So that is talked about in section 22. Then what is the effect of admissions by partners? What he does or what he says. That is, insofar as the third party is concerned, that is provided for in section 23. Then notice to an acting partner by a third party will be deemed to be a notice to the firm and all the partners. Then liability of partner for the acts of the firm, then liability of firm for wrongful acts of the partner. So if someone does a wrongful act, then the firm will be liable to the third parties. Here, the emphasis is all on the liability to third parties. Then subsequently, what happens if the firm is liable and the firm is asked to pay up? Then you will have to go to chapter 2 to see that there is a provision relating to indemnifying the partners, indemnifying the firm for the loss caused by the person, caused by the fraud of another person, caused by the willful neglect of the partner. For those provisions, in terms of taking money from him and indemnifying the partners you will have to see chapter 3. But here the focus is on Liability to third party, rights and duties vis-a-vis third parties. Then section 28 is about the holding out. That is, someone will be representing himself by his act, word, or conduct that he is acting on behalf of the firm. So if he does that, then the firm acquires in it, or the third party acts based on that, then the firm will be bound by it. So this is the principle of holding out. Then sometimes the interest of a partner is transferred. So what will be the rights of the person to whom the partner's interest is transferred? That is covered in section 29. Then special position of a minor in admitted into partnership is dealt with in section 30. So now let us see individual sections. Section 18 talks about partner to be an agent of the firm. So again, it says subject to the provisions of this act, partner is the agent of the firm for the purposes of the business of the firm. So here, the classic example is that of mutual agency, which I talked about. So the same case of Cox versus Hickman will be applicable here, where there was a committee of creditors. The company, the firm B. Smith and J. Smith, which was dealing in business of iron workers and corn merchants, they owed money to a lot of creditors. So they entered into an agreement with those creditors, and then they entrusted the whole task to something called as Stanton Iron Company to carry on the business and recover the money and distribute it so that the liability will be taken care of and no marking back of the liability to Smith. So Cox was one of the trustees. Cox did not act as a trustee, but Wheatcroft, who was also in the committee of creditors, acted as a trustee, and then he resigned in 6 weeks, after which no trustee was there. This Hickman gave goods and drew 3 bills of exchange and sent it across to them. The bills were not were accepted but not paid. So the suit was filed by Hickman against Cox, and it was indicated whether the relationship between the creditors is that of a partnership or whether it is not. So if it is a partnership, then Cox will be liable. If it is not a partnership, then Cox will not be liable. So the court held that whether there is mutual agency among the creditors, then it said that no, there is no mutual agency. Creditors did not operate the business. The deed of arrangement is basically a mechanism to get the repayment of the amount and get themselves paid for the money they owed to Smiths. So it does not fulfill the requirement of partnership. So then it was indicated here that if 2 or more persons are to carry out a trade and share profits, each is a principal and each is an agent for the other. And because of this operation of person being an agent and the principal, each is bound by the other's contract and carrying of a trade as much as a single principal would be by the act of an agent who was to give the whole profits to the employer. So this was what the court ultimately held. So a partner who transacts business for himself as principal and for others partners as an agent. So the partner basically operates in dual capacity. So he operates as a principal while he is acting, and he operates as an agent insofar as binding the other partners are concerned. Then because he is acting as a principal, there is no general right of remuneration to him. But because he is a principal in it, he is entitled to a share of the profits. And partnership is basically a contract of mutual agency. It's one of the most essential elements of partnership. Now, what is the implied authority? So implied authority of a partner as agent of the firm. So subject to provisions of section 22, which talks about how do you do something to bind a firm. That is what is provided for in section 22. So subject to the provisions of section 22, the acts of a partner which is done to carry on in the usual way business of the kind carried on by the firm binds the firm. So the authority of the partner to bind the firm conferred by this section is called as the implied authority. So we'll see what are the various examples of implied authority and how do you presume that there is an implied authority. So where there is no express authority. So that's the reason why a partnership deed is very, very important, where you draw up what is the authority of each person. But if you don't have that, there are certain presumptions which come into play, which will be provided, which have been provided for under the provisions of the Partnership Act. So if you have a partnership deed and a well-written agreement indicating the specificities, you don't have to look at or bother about the implied authorities. So implied authority for an act to be treated to be done with an implied authority, it should be an act done to carry on in usual way the business of the firm. So in the usual way, so here there has to be something which whether something is with implied authority or not, you will have to see whether it is so or it happens usually depending upon the nature of the business, depending upon the practice as far as that business is concerned, and the general usage that is there in conduct of the business. So can there be an implied authority of to borrow in every partnership firm? So it depends upon the kind of business that is there. So where there is a trading firm, you are buying and selling goods, you may need to have credit, in which case there could be an implied authority to borrow. Whereas there is a professional firm like a chartered accountant, so there need not be any necessity for borrowing, because it's more of a profession that is involved, where you are dispensing advice or you are dealing with the documents, etc. So then an auctioneer who sells, so he merely sells goods. Then a commission agent and engineering contracts, etc., they don't need to borrow. So here, if someone says that I borrowed with an implied authority, no implied authority will apply in these kind of cases. But if the firm is dealing in finance, then you can say that the ability to borrow is an integral part of financing, provided the law provides for it. Then it can be treated to be done with an implied authority. So partners have an implied authority to defend in legal proceedings against the firm and engage a lawyer. So this is basically necessary because my interest would be affected by the litigation. So I should be in a position to defend, and I should also be in a position to engage counsel, advocate for dealing with this litigation. Then what are the other instances where implied authority could be deemed is where to engage servants for doing the business, for buying goods on credit, then receiving payments, taking premises on lease, operating account opened by partners, and then if there is any problem, stopping payment, etc. So these are the things where implied authority can be assumed. So some of the cases that we can see are cinematographic theater business was being conducted, and the deed made it necessary that mandatory approval of partners should be there before borrowing. So there is an express clause in the agreement saying that there has to be an approval of partners before borrowing. In spite of that, one partner borrowed and misappropriated the money. So here it was held in this Higgins versus Bucamp that there was no implied authority to borrow, as the firm is of cinematographic business but not a trading firm, and there is an express clause indicating approval, so the other partners are not liable, and there is no implied authority to borrow, and more importantly, there is an express prohibition or restriction against borrowing, subject, and they could borrow only with the approval of all the partners. So that's as far as this Higgin versus Bucamp case is concerned. Then in Suryamurthy versus Chandra Devi, criminal prosecution for dishonor of check for payment of dues by the partnership firm was done. So then the payment is supposed to be made, or the prosecution is supposed to be conducted. So only those partners who have participated in the business, they will be liable, but those who have not participated in the business will not be liable, is what the court held. So those sleeping partners, kind of the persons who are not actively involved in the partnership firm's business or financial dealings, they will not be liable for dishonor of check. So where there is a specific mention then of the authority, then that is called express authority. So here where there is no specific mention, you are having a implied authority to do some things and bind the firm. So where there is an express authority, then the partner cannot exceed that authority. So something so where there is no express authority and deeming that there is implied authority, the partner does something. Then If the firm and other partners subsequently ratify it, then it can be deemed that this act has been done with implied authority. So section 19(2) talks about what are the areas where there are you cannot imply authority. So in the absence of any usage or custom of trade to the contrary, the implied authority of a partner does not empower him to. So if there is a usage, custom or of trade which provides for implied authority in respect of these cases, then that is okay. But where there is no usage or custom of trade, so there cannot be, you cannot assume implied authority in the following cases. So the cases are also very typical and self-explanatory also, that submitting a dispute relating to a business firm to arbitration is something which a partner cannot be doing, because arbitration could result in an award which could be having implications. So that freedom to decide or submit a dispute to arbitration should not be exercised by one person. It has to be done, it has to be expressly granted to someone, or it has to be done with the concurrence of all the partners. Then opening of a bank account on behalf of the firm is okay, but then in his own name, this cannot be deemed to be an implied authority. So if it is supposed to be done in the firm name, then it's a different thing. But there cannot be an implied authority to open the firm's account on behalf of the firm in my name. Then compromise or relinquish any claim or portion of a claim by the firm. So it's basically any money that is due to the firm, that is all the partners. So one of the partners cannot say that you don't need to pay me this money. So other people's rights are affected, because of which you cannot, there cannot be a case for implied authority for compromise or relinquishing any claim. Then withdraw a suit or proceeding filed on behalf of the firm. So here also, the fact that the firm has taken up litigation itself is something which is of importance. So someone going by himself and then withdrawing the suit or proceedings will not be in the firm's interest. So this, you cannot assume that there is an implied authority for any partner for withdrawing the suit, which has been instituted based on the consent of the partners or in accordance with the terms of the partnership agreement. Then admit any liability in a suit or proceeding against the firm. So if he is doing for himself, it's a different thing. But if a partner admits liability and if he is deemed to be having an implied authority, then he will bind the other partners and the firm also into the liability. So this being joint and several liability and unlimited liability, it is not something that can be permitted to be done by a partner in exercise of his implied authority. Then acquiring immovable property on behalf of the firm, then transferring immovable property belonging to the firm. So this big commitments need to be done with express authority and not, or concurrence, and not in accordance with assumed implied authority. Then enter into a partnership on behalf of the firm. So this is also something binding the partners further into some other legal relationship or another liability. That is not something which a partner can do. So these are the instances where implied authority cannot be presumed unless there is a customer usage to the contrary. Now, by agreement between the partners, there could be an extension or restriction of the partner's implied authority. So the partners of a firm, according to section 20, the partners in a firm may, by contract between the partners, extend or restrict the implied authority of any partner. And when will this be effective? One, notwithstanding any such restriction, any act done by a partner on behalf of a firm which falls within his implied authority binds the firm, unless the person with whom he is dealing knows of the restriction or does not know or believe that the partner to be a partner. So the extension or restriction can be made by contract between the partners. For any partner, what is the authority? Then suppose the restriction is placed, will the restriction be operational by itself? No, because where some act can be deemed to be by implied authority, then the third party has to be given the benefit of having that implied authority. When can you not give him the benefit? Only when you make it known to him that there is this restriction. And otherwise, if the person with whom he is dealing, if he is dealing with him as if he is an individual, then the partner, then that it will not be deemed to be an implied authority, because the person who is transacting, the third party who is transacting with this person, does not even know that he is a partner of the firm. So in these two cases, the restriction will not apply. Otherwise, any restriction or extension has to be made with, has to be communicated. More specifically, restriction, because if someone does something to a partner, he wants the firm to be liable for whatever he has done to the partner. For that to be there, you impose restrictions, and those restrictions should be made known. This is as far as the section is concerned. So then a case in this regard is Mercantile Credit Company versus Garrod. So here the firm was engaged in garage and repairing of cars. So generally in garages and repairing of cars, selling or buying of cars also happens normally. But here in this particular agreement, there was a clause which prohibited partners from buying and selling cars. So in spite of this clause, one partner sold a car, and that car, while he was selling, he didn't have a title. But after selling the car, he received the money. So the buyer came to know that the partner of the firm did not have the car did not have a proper title, so he came back. Then he claimed money from the sleeping partner of the firm. Not the, he couldn't trace the partner who was sold in the car, so he came to know about the sleeping partner from the firm, and he claimed money from him. So here it was indicated that the sleeping partner was liable, because generally garages are dealing in cars, and if there is a specific restriction from dealing in cars, prohibition on buying and selling of cars, that prohibition has to be made known to people. And if that is not made known, then you will not be in a position to deal with it. So buyer did not know of the restriction and thought that the partner operated as per the implied authority. So here it was not the sleeping partner with whom he was dealing, but an active partner. So an active partner, if you are dealing with and you don't know the restriction, then you can hold the firm liable. But where if you would have dealt with the sleeping partner, then it is, this person is not someone who is acting on behalf of the firm. The other person would not know that he is acting as a partner. In which case, again, the restriction would not apply. So here, this is the provision as far as implied authority and restriction of the implied authority. Then the restrictions and impact. So restrictions, as I discussed, statutory restrictions are in 19.2. What are the things that cannot be implied to be, cannot be done under implied authority? Then by agreement, you could have restrictions and you could have extensions under section 20. So while statutory restrictions are deemed to be known and binding, contractual restrictions or modifications are not deemed to be known, and they will be operating only when they are made known, or if the person does not know of the person with whom he is transacting to be a partner at the time of the transaction. Then in case of an emergency, if any partner does something, then he should be in a position to bind the firm for such acts. So that is section 21. So a partner has authority in an emergency to do all such acts for the purpose of protecting the firm from loss, as would be done by a person of ordinary prudence in his own case, acting under similar circumstances, and such act binds the firm. So here, the requirements for binding the firm in case of an emergency is that there should be an emergency. Then the partner who is there has acted for protecting the firm from loss or from loss caused by the emergency. And this action that he is doing is, as it is done by a person of ordinary prudence. If he would have been subject to this emergency, what he would have done under similar circumstances, if he does that, and if it is reasonable, then he will be binding the firm. Then section 22 is talking about act binding the firm. So what is the mode of doing an act to bind the firm is what is indicated in section 22. In order to bind a firm, an act or instrument done or executed by a partner or other person on behalf of the firm shall be done or executed in the firm name or in any other manner expressing or implying an intention to bind the firm. So in order to bind the firm, whatever is done, or if an instrument is executed, that instrument has to be executed by a partner or other person on behalf of the firm. So here, if you see the definition of partnership, any person or his agent acting on behalf of all. So if another person also could act, and if he does this act or if he executes the instrument in the firm name, or if he does so in any manner to imply the intention that he wants to bind the firm, then it will be treated as doing the act binding the firm. So the act should be expressly or impliedly done so as to bind the firm. So if it is doing it in the firm name, it's a sure short way of binding the firm. Then second, indicating an intention to bind the firm for the particular act. So if it is not done in that manner, then it will not be that the firm will not be liable, but the individual partner will be personally liable. So some of the examples of court cases, etc., are signing of a bill of exchange with managing proprietor and as managing proprietor and indicating the firm name. It was held that the signature indicated the status of person signing, but it did not indicate the intention of the person to bind the firm. So it was held that the person himself was liable. Then in executing a promissory note in the firm's name. So here, anything which is executed or done in the firm's name, then automatically it will be an act which will be binding the firm. So it was held that the act was binding the firm. Then receiving money by check in the firm name by a person who was not a partner. So here, a person who's not a partner is receiving the check in given in the name of the firm, and suppose subsequently he pilfers it and he takes it, then the firm will be held liable. So here, the firm liability cannot be ignored, and the firm and the claim against the firm and partners can be enforced. So here, the principle of holding out also will apply in this particular case, where the person who was collecting the instrument, the other party thought that he was acting like an agent of the firm. So this principle is what is called as principle of holding out. So in accordance with holding out also, the person will be liable. Then Section 23 talks about effects of admission by a partner. So an admission or representation made by a partner concerning the affairs of the firm is evidence against the firm if it is made in the ordinary course of business. So here, this is in relation to admissions or representation. So whatever is said during the course of the business of a firm, that can be used as evidence against the firm. So the statement made about the existence of a fact, which includes even a misrepresentation, if made in the ordinary course, it is admissible and it is liable to be used. So suppose an acknowledgement of debt by a partner is given. So this is sufficient to extend the limitation period for the recovery of a particular debt. So this is not applicable to the scope of implied authority. Then notice to acting partner is a notice to the firm. So effect of notice to acting partner is what is discussed in section 24. So notice to a partner who habitually acts in the business of the firm of any matter relating to the affairs of the firm operates as notice to the firm, except in case of a fraud on the firm committed by or with the consent of the partner. So in the previous case that we have seen, someone has issued a check to a person. If he is coming in and taking this in the normal course, he is habitually acting on behalf of the firm and he is receiving the checks from people, then it will be deemed to be acting by the firm. So if the fraud, in this particular case, he has committed fraud, but since it was not committed with the consent of the partner, it will not be treated as acting by the firm. So in case of a fraud on the firm committed by or with the consent of the partner, then the notice to the partner will not be treated as notice to the firm. So in that particular case, it was there was no consent of the partner to escape liability, though there is a fraud. Then liability of partner for acts of the firm, section 25. Every partner is liable jointly with all the other partners and also severally for all acts of the firm done while he is a partner. So this is the principle where joint and several liability of the partners is established. So every partner is liable jointly with all other partners and also severally. That is, suppose a partnership owes 100 rupees to a third party, then every partner is jointly liable for that 100 rupees, and individually each partner will also be liable for 100 rupees. So jointly liable for 100 rupees, it can be recovered from them together. Otherwise, if nobody is in a position to pay, I can recover from each one, any one of the person 100 rupees. So severally they are liable. And once the money is received, the partners can in turn get the money from the other partners. For that you will have to go to the provisions of chapter 3, where indemnifying for payment, etc. will be applicable. Then requirements for liability of partner. For all acts of the firm done while he is a partner. So even a sleeping partner is liable for the acts of the other partner, which we have seen in this particular case that we have dealt with. Previously, we've done some case. Requirements of liability of a partner. For all acts of the firm done while he is a partner, even sleeping partner is liable for acts of the partner, other partners. Using firm's property by partner amounts to acts of the firm by the partner. So we have already seen section 22. Then partner's liability for acts done after moving out of partnership. So a retired or an expelled partner is liable only if he is holding out. Otherwise, if he moves out of the firm, then he will not be liable. So here the liability will be joint and several for all the acts of the firm, and if it is done while he is a partner. But the liability will extend beyond his tenure as a partnership if he is retired or if he is expelled or if he is a minor who is opting out, unless he gives a public notice to the world at large saying that I am not a partner anymore. So this, for retiring expelled partners and for the minor opting to not become a partner, the principle of holding out will apply, which we'll see in section 28. But the liability of holding out will not be applicable, and liability of the estate or the property of a partner will not be there in the event of death or insolvency. So here, there is a case of Dena Bank versus Bhika by Prabhudas and Company. So this was in relation to recovery of sales tax dues from proceeds of sale of property mortgage to the bank. So here, it was held that the partners are liable personally for the dues payable by the firm. And where the firm is deemed to be a person or legal entity for the statutory purposes, the partners will not be personally liable. So in section 184 of the Income Tax Act, a partner will be treated as a distinct legal entity, and in which case that will be treated, the partnership will be liable. But here in the Sales Tax Act, partner will not be personally liable unless the statute provides for the same. So here in this particular case, Karnataka Sales Tax Act provided for personal liability of partners also for the tax due. So here the money could be recovered from the partners, and because the act provided for them to be personally liable. Then in case of Nazneen versus Director of Enforcement, so a firm committed Foreign Exchange Regulation Act violation. So here the partners of the firm were held personally liable for the contravention of the Foreign Exchange Regulation Act for the business that was conducted when they were partners. So joint and several liability is applicable in case of recovery of sales tax dues as provided for in the Karnataka Sales Tax Act. And secondly, they are also personally liable for any violation done during the time that they were partners under the Foreign Exchange Regulation Act. And the liability will be joint and several. Then there is this case of Glorious Plastics versus Laggate Enterprises. So one partner retired and the other continued in the partnership. So there was a bill of exchange which was accepted by the partners 3 years after retirement, and the plaintiff, which is the retired partner, did not have any knowledge of the retired partner being in the firm. So the retired partner here was held not liable because he is not a part of the firm. Then second thing, he was not holding out. That is, he was not representing himself to be continuing in the partnership firm. So because of these two things, the retired partner, when they brought an action against him, it was held that he was not liable. In Seshi Ammal was and another versus Vairavan Chettiar. So here the representatives of deceased partner sued for amount advanced to the firm after the partner's death to honor bill of goods ordered when he was alive. So the goods were ordered when he was alive. Then the payment was sought after the partner's death. So from the partner's estate, deceased partner's estate, they wanted the money to be recovered. So the court held that that is not, the deceased partner's estate is not liable because the liability has come out after the death, and assets of the partnership of the surviving partner are only liable. And in the case of a death, you cannot even indicate that holding is applicable. So the goods were delivered subsequently, and the liability in relation to this arose subsequent to the death of the partner. So the deceased partner's estate is not liable. Then same as the case in Bagel versus Mirror, the supplier sued for estate of deceased partner for liability of all goods contracted for supply to partnership, of which he was a partner. So some goods were delivered before death and some goods were delivered afterwards. So it was held that he was not liable for goods delivered after the partner's death. Only liability was there for the goods delivered to the partnership before his death. Because the obligation to pay arose on delivery, the debts relating to the goods delivered after the partner's death was incurred after he ceased to be a partner. So the estate of the deceased partner is not liable. This is the case of Bagel versus Mirror. Then liability of the firm for wrongful acts. So whereby the wrongful act or omission of a partner acting in the ordinary course of business of a firm or with the authority of partners, loss or injury is caused to any third party or any penalty is incurred, the firm is liable therefore to the same extent as a partner. So here, if any partner who is doing anything in the normal course of business or with the authority of the partners, and this act or omission of the partner is resulting in a loss or injury to any third party, and for that purpose a penalty is incurred, then the firm is liable therefore to the same extent as the partner. Then liability for misapplication by partners. So where a partner acting within his apparent authority receives money or property from a third party and misapplies it, or a firm in the course of its business receives money or property from a third party, and the money or property is misapplied by any of the partners while it is in the custody of the firm is liable to make good the loss. So here, where the partner acting based on his apparent authority, he receives money or property from a third party and misapplies it, then also the firm will be liable to the third party. Then the money has come into the firm and this money has been misappropriated by one of the partners while it is in the custody of the firm, then also the firm is liable to make good the loss. So the instances here are wrongful act or commission, then misapplication of money either by the partners or by the firm. In both the cases, the firm will be liable. Now we come to the doctrine of holding out. So now we go to doctrine of holding out. Section 28 of the Act deals with it. So here, the section says anyone who by word spoken or written or by conduct represents himself or knowingly permits himself to be represented to be a partner in a firm, he is liable as a partner in that firm to anyone who has, on the faith of any such representation, given credit to the firm, whether the person representing himself or represented to be a partner does or does not know that the representation has reached the person so giving credit. So here, the various elements of holding out are coming out in this particular section, which we will discuss. The first thing is there has to be a representation by word spoken or written or by conduct. So the person himself must be representing to be so, or knowingly permits himself to be so represented. Then what is he representing himself to be? A partner of the firm. And such person is liable as a partner in that firm to anyone who has. So if such representation by himself, or if permitted by him by someone else as a partner, and based on this representation someone else does something, so for that given credit to the firm, etc., then the partner will be liable for the credit given to the firm based on such representation. And it is immaterial whether the person representing himself or represented to be a party does or does not know that the representation has reached the person so giving credit. So it's not necessary that I should know that I have, whether my representing to be a partner has reached him or not. If that is immaterial. Then holding out, where after a partner's death, the business is continued in the old firm's name, the continued use of that name or of the deceased partner's name as a part thereof shall not itself make his legal representative or his estate liable for any act of the firm done after his death. So where there is a partner, say X and Y, and X dies, and the name of X and Y continues to be there in the firm, and by having that, if they are doing the business, then for whatever is done after the death, the estate of Y will not be liable for it, because death is a notice by itself and no specific notice is required in case of death. So who are the persons who can be liable? So he says anyone who represents himself or knowingly permits himself to be representing to be a partner in the firm. So here it could be persons who are not partners also, or it could be persons who have moved out of the partnership. So in case of persons who are not partners, it could be employees, it could be agents, etc. Then persons who have moved out, it could be retired partners, it could be expelled partners, or it could be minors who could choose that I don't want to be a partner. So these persons are liable, can be held liable for holding out. And what are the prerequisites for holding out? First, the representation as partner by word spoken, written, or by conduct. So here it could be representation by the person himself or someone else. So that both these representations will be treated as representations for the purpose of holding out. Then third party having knowledge of the representation and acting based on it. If the third party is aware based on this knowledge that he is a partner or he is acting on behalf of the firm, he makes something, then the partner and the firm will be liable. So there will not be any liability for holding out in case of deceased partner, insolvent partner, and a dormant partner. So examples we can see through certain cases. So representation as partner by words, spoken, written, or by conduct. So here, first of the instances will be allowing use of person's name in the firm name. In a case of Bevan versus National Bank, MW was a manager of B's business, and the business was carried on as if it was MW and Co. So MW was actively involved in bills, documents, checks. So he was acting as if he was a partner in the firm. So here, MW was also held to be liable and B was also held to be liable, because the name of the firm and the name of the manager who is active is there, though he is not a partner. Then here, but he was merely a manager. The second case is of Kirkwood versus Cheetham and Smith. So Cheetham, a butter dealer, engaged Smith as a servant to manage business under the name Smith and Company. So the supplier held that both Cheetham and Smith were liable because Smith was holding himself out as an agent, and Cheetham was holding himself out as a principal. Then second, giving an impression that the person is a partner. So for this, the example is case of Bass Brewers versus Appleby. So here, generally in insolvency processes, you have an insolvency professional who is generally a chartered accountant, company secretary, advocates, etc. So here, in this firm, a chartered accountant was engaged as an insolvency professional, and whenever you are selling any, disposing of any property as a process of insolvency, you are getting money, and that money is received in the form of a check. And the check, though it is given in the firm's name, it was being received by the chartered accountant. So he received money representing sales proceeds of mortgage property, and he did not account for this amount, and he became insolvent. So in this case, it was held that the partners to the agreement were liable, as they allowed the chartered accountant who was not a partner to be holding out as a partner of the law firm. So here, the person is not acting like a partner, but the persons are permitting, the other partners are permitting him to be acting like an agent or acting like a partner. So in which case, the principle of holding out will apply. Then the third instance is knowingly representing or allowing to be represented as a partner. So in this, for this, you have a case of Tower Cabinet Company versus Ingram. So here C and I carried on first furniture business. I retired and C continued. And the supply of furniture was happening there even after I retired, and the payment was not made. So subsequently, when they saw the paper, they found that I's name is also there. So they filed a case against I and sued him and wanted the money to be recovered. So here, the court held that the note paper used was for placing the order in C had I's name and without I's knowledge, and it was without I's knowledge or authority, because of which, and he was not representing himself to be a partner, so he cannot be held liable for holding out. So it was held that I, who retired from the partnership, was not liable. The only thing that could have been done is he should have destroyed the papers having his name. Then the second thing is a case where someone acquiesces in being named as a partner. So in Martin versus Gray, A introduced B to C as a partner while he was not a partner, and B did not object for being introduced as a partner. Then the relationship happened, and subsequently, when the liability was supposed to be there, B was held liable for holding out, and the firm was also held liable for holding out. Then third party having knowledge of representation or acting on it. It's necessary that the third party should be acting on the basis of the representation, and after having knowledge of the representation. Only then there should be a belief in the representation. He should have knowledge of the representation, and based on that, he should have acted and given credit to the firm. If these requirements are there, then he will be then there will be a liability towards the third party, and the firm and the partner will be held liable. So if the third party would anyhow deal with the firm, then it cannot be held liable for holding out. So if the dealing would have happened irrespective of whether he knows of the representation or not, or it's in the normal course of business, then you cannot say that the partner or the firm is liable. And as I told you, it is not material whether the person representing or being represented knows or does not know that the representation has reached the party. So irrespective of whether it has reached, I didn't know that he would know about it, that kind of an argument will not be sufficed. So it will not cut eyes. Have you represented yourself or permitted yourself to be representing to be a partner or not? If the answer of it is yes, then whether it has reached him, I didn't know about it, these will not apply. And based on this representation and knowledge and belief in it, that if the third party acts and gives credit to the firm, then the principle of holding out will be applicable. So a retired partner can be liable if public notice is not given. So that's the reason why in case of retired partners, expelled partners, and what is it, in these two cases, it is the retired partner or the expelled partner or the partners of the firm. Anyone can go and give a notice. So the retired partner will give a notice if he doesn't want to be held liable for the purpose of holding out. The existing partners who are there will give a public notice saying that this person is no more a partner, according to section 2072. In which case, they what is it? If they don't give that notice, then they will be liable for on the basis of operation of estoppel. So from that point of view, holding out will be applicable for the person going out, and estoppel will be applicable for the continuing partners because they are acquiescing on the fact that this fellow is a partner, and if someone acts on it, then their liability of the firm will not be escaped. In these cases where the person is going out, for him not to be held liable, in his own interest, he has to give a public notice according to section 72, after which only he will not be liable for holding out. Then what are the instances where public notice is not required? One, in the event of death. Estate of the deceased is not liable from the date of the death of the partner, even if the surviving partners continue. So that is a notice by itself. In case of insolvency, which is civil death, the liability will be terminated immediately, and the estate of the insolvent will not be liable from the date of the order of insolvency. Then, in case of a dormant or sleeping partner, the existence of the partner in the firm is not reflected in the conduct of the business, then liability will be only for acting apparent and ostensible partner. So a dormant or sleeping partner cannot be held responsible for being liable for holding out, because the world does not know that he is a partner. So acting in relation to him does not bind him, does not bind the firm. So that is as far as the aspect relating to holding out is concerned. Then the next provision is relating to rights of transferee. So a transfer by a partner of his interest in the firm. How can you transfer? You can transfer it by mortgage, by creation of a charge. You can either transfer the whole thing, or you can transfer the interest in that property. So this mere transfer of interest in the firm does not entitle the transferee during the continuance of the firm to interfere in the conduct of the business, or to require accounts, or to inspect the books of the firm, but it only entitles him to receive the share of profits of the transferring partner, and transferee shall accept the account of profits agreed to by the partners. So here, there is no bar on the transferee, on the partner transferring his interest by whichever way possible to another party. But that, as long as the firm is continuing and the transferee is having this interest, he will be eligible only to receive the profits. Then for that purpose, whatever accounts are agreed by the partnership firm, he can take that. He can't call for accounts, then he can't interfere in the conduct of business, or he can't go and inspect the books of accounts of the firm. So this is as far as the right is merely to receive the share of profits of the transferring partner. Then if the firm is dissolved, or if the transferring partner ceases to be a partner, then the transferee is entitled, as against the remaining partners, to receive the share of the assets of the firm to which the transferring partner is entitled. And for the purpose of assigning that share, he is entitled to an account as from the date of dissolution. So here, what are the two things that are there? One, a transferee partner, and that firm is continuing. Second is a transferee partner, transferee of a partner's interest. The firm is continuing. Second is the firm discontinues. Where the firm is continuing, he cannot become a partner because it is a relationship of trust and confidence. Then any admission of a partner has to be with the consent. So even a legal heir does not have an entitlement to become a partner. So a person to whom the interest is transferred, at the most what he can do, he can receive the share of profits. Then whatever accounts are indicated by the firm, that has to be taken into account, and based on that he will receive profits. He cannot interfere in the business, he cannot ask for accounts, and he cannot inspect the books. But where the transferring partner ceases to be a partner or the firm itself is dissolved, then because he has an interest of the from the partner, he is entitled to receive the share of assets which the partner is entitled to receive. And for this purpose, he has a right to call for the accounts as on the date of dissolution, because he will have to know how much money he is going to get. Then the next important aspect here is relating to minor admitted to partnership. So minor admitted to partnership, section 30. So here, a person who is a minor according to the law to which he is subject may not be a partner in the firm, but with the consent of all the partners for the time being, he may be admitted to the benefits of the partnership. So here, capacity to contract is very important for parties to for a partnership agreement also. So in that sense, minor does not have the capacity to contract. So, however, he can be admitted for the benefits of the partnership by in what manner? By with the consent of all the partners who are there for the time being. And what is the age of till which he will be considered to be a minor? The law to which he is subject will be the applicable law. In our country, Majority Act 1875, Section 3 says the age of majority of persons domiciled in India. Every person shall attain majority on his completing the age of 18 years and not before. So anyone who has not completed 18 years, if he wants to be admitted as a partner, he cannot be. If he can be admitted only for the purpose of getting the benefits of partnership, then that too, he can be admitted only based with the consent of all the partners who are there at that point of time in the partnership firm. So then what is the right and liability? So such minor has a right to such share of property and of the profits of the firm as may be agreed upon, and he may have access to and inspect and copy any of the accounts of the firm. So here he is admitted to the benefits, and benefit is, in the case of partnership firm, is a share in the profits. So that share in the profits will also be agreed upon at the time of admitting the minor. So during the course, he is entitled for that share. Then he has access to, he may have access to and inspect the accounts and also take a copy of the accounts of the firm. So such minor's share is liable for the acts of the firm, but the minor is personally not liable for any such act. So there is a share which is given to the minor and a share of profits and benefits that are going to be given. So that share of the property and share of the minor will be financially liable, but there will not be any personal liability for any act in case of a minor. So it's only its share and financial liability that will be there, but no personal liability. So here, what are the minor's rights? He has right to share in the property as per the agreement, and he has right to profits as per the agreement. Then he has right to have access to the accounts and inspect and copy any of the accounts. But this right has to be provided by the, it is there, but it has to be provided by the existing partners. But if they are not providing, what is the instance? We will have to see section, the subsequent subsections. The minor liability is only for the acts of the firms, and there is only financial liability to the extent of his share, but there is no personal liability. Then what happens if actually they agree to give him a share in the profit, they agree to provide him a copy of accounts, etc. But if they don't do that, can an action be brought about? That is what is discussed in subsection 4, which says, such a minor may not sue the partners for an account or payment of his share of the profits or profits of the firm. Share of the property or profits of the firm. When can he do that? So as a principle, while he is continuing in the partnership, as a person who is entitled to benefits. If the share of property is not given, if the share of profits is not given, or if the accounts are not produced to him, so then he cannot sue the partners, but he can sue only when severing his connection with the firm, and in such case, the amount of his share shall be determined by valuation made as far as possible in accordance with the rules contained in section 48. So here, as long as he is continuing or he has an intention to continue, he cannot sue. Either if the profits share is not given, or if the share of property is not given, or accounts are not shown, or a copy of accounts are not shown to him. But if he wants to file a case for getting these, then he will have to sever his connection with the firm. And once he severs his connection and files a case, his share of property will be determined in accordance with section 48. So 48 is a provision which deals with the mode of distribution of assets and allocation of profit, etc., which is in the provisions relating to dissolution. The chapter dealing with dissolution, we will have section 48. So here, now the suit is provided. So the provisos provide an opportunity for a partner to use this suit for dissolution of the firm itself, or all the partners to agree to get the court to take up the matter as if it's a suit for dissolution of the firm. So it says, provided that all partners acting together or any partner entitled to dissolve the firm, upon notice to other partners, may elect in such a suit to dissolve the firm, and thereupon the court shall proceed with the suit as one for dissolution and for settling accounts between the partners, and the amount of the share of the minor shall be determined along with the shares of the partners. So if the suit by the minor is filed, the only thing that will happen is the court will examine that and indicate that you distribute whatever share is there in accordance with section 48, and his portion will be taken and the firm will continue. But in this particular suit, if all the partners acting together or any partner who is entitled to dissolve the firm according to the terms of the partnership agreement, then he will give a notice to all the partners and elect in this particular suit filed by the minor that he will ask the court that you dissolve the firm, and in which case the suit by the minor will be treated as a suit for dissolution and settling of accounts between all the partners. And just like in this resolution where the minor's share is determined, all the shares of the partners are also determined and distributed. So the provision says that minor cannot ask for accounts or share of property or profits while continuing in the firm. He can ask for them and sue partners only when he wants to sever connection with the firm. In such a case, his share is determined by valuation norms as per rules in section 48. In this suit, a partner authorized or all partners, after notice to all partners, may opt for dissolving the firm. The court will proceed as if it's a dissolution and for settling accounts between the partners, and the share of minor and the partners will accordingly be determined and distributed. So now what happens if the minor attains majority? So at any time within 6 months of the minor attaining majority or of his obtaining knowledge that he has been admitted to the benefits of the partnership, whichever date is later, such person may give public notice that he has elected to become or he has elected not to become a partner of the firm, and such notice shall determine his position as regards the firm. So here, it may so happen that someone may be admitted into the benefits of a partnership, but he may not be aware of it. He may probably get awareness of this at some later point of time. So, which could be even after he has attained his majority. So, the section talks about the choice that is given to the minor. So, if the minor, after he attains majority, within 6 months of his attaining majority, he has to give it by public notice, indicate whether he wants to continue and become a partner or whether he wants to not continue and opt out of the partnership firm. And that notice will determine his position. Suppose he gets to know about this later, after he has attained 18 years also, and at that point of time, from there 6 months after of his getting the notice, whichever point is later, he should give a public notice to indicate that whether he wants to continue in the firm or he wants to go. Provided, what will happen if he fails to give the notice? Then there is a default option that is there. That is, he shall become a partner in the firm on the expiry of the said 6 months. So, if he does not exercise his choice of either to become a partner or not to become a partner, either after attaining majority or within 6 months of attaining majority or 6 months of getting to know that he is admitted into the benefits of the partnership, whichever is later, then after the 6 month period is over, he will automatically become the partner of the firm. Then where a minor has been admitted as a minor, where any person has been admitted as a minor to the benefits of the partnership in a firm, the burden of proving the fact that such person had no knowledge of such admission until a particular date after the expiry of 6 months of his attaining majority shall lie on the person ascertaining the fact. So what is the burden of, who has the burden to prove that he got knowledge about it only now? So it will be on the person who is asserting the fact. So here, power of the minor to elect becoming or not becoming a partner has to be exercised within a period of 6 months of majority of attaining majority or 6 months of knowledge of admission to benefits, whichever is later, and he has to elect by public notice. Again, section 72, you will have to see what is the default option. If he does not give his notice, he becomes a partner automatically after the expiry of 6 months. So the benefit of time beyond 6 months after attaining majority for exercising choice to not become a partner only if he proves that he has a knowledge of being admitted as a partner for benefits and he got to know about it recently. Only then he will be in a position to get the benefit of 6 months period after his majority also. Then so the burden of proof is on the minor if he does not want to become a partner, and on the partners if they want the minor to share the liability. So I'm a partner. When will I indicate that I got to know what is it only now? Because the default option, I don't want to become a partner, then I will say that I got to know about it just now. So the minor will have to prove in case he does not want to become a partner. So the other consequence of this fellow becoming a partner is the liability will be distributed amongst the minor also. So the personal liability also will start if he becomes a minor. So to spread the liability, the partners in the existing firm or third parties would want him to be also brought into the partnership firm, in which case they will have to prove that he already knew about it, but he is not exercised his choice. So the default option of him becoming a partner has to operate. Then where such a person becomes a partner, his rights and liabilities as a minor continue up to the date on which he becomes a partner, but he also becomes personally liable to third parties for all the acts of the firm done since he was admitted to the benefits of the partnership, and his share in the property and profits in the firm shall be the share to which he was entitled as a minor. So if the minor becomes a partner, so the minor's rights and liabilities will continue till the date he becomes a partner. Then on becoming a partner, his rights, as far as his share of property will remain the same, share of profits will be remaining the same as it was when he was a minor. As far as the liability is concerned, he was already having the financial liability up to his share, which will continue to operate. But personal liability to third parties for acts done by the partnership will continue, will date back to the date from which he has been personally admitted into the benefits of the partnership. So the personal liability also will kick in from a back date, the date on which he has been admitted into a partnership. Now, in case he does not choose to become a partner, what will be the impact will be subsection 8. So where such person elects not to become a partner, his rights and liabilities shall continue to be those of a minor under this section up to the date on which he gives public notice. And his share shall not be liable for any acts of the firm done after the date of the notice, and he shall be entitled to sue the partners for his share of the property and profits in accordance with subsection 4. Then nothing in subsection 7 and 8 shall affect the provisions of section 28 of the Act, which deals with holding out. So The rights and liabilities, the minor chooses not to become a partner, then the rights and liabilities continues to be those of the minor till he gives public notice. And after he gives public notice, his share is not liable for any acts of the firm after the date of the notice. Then second thing is he can sue the partner for his share of the firm property and profits according to subsection 4, where he will file a case and then he will ask for his share to be given, and in that same share the court will decide his share and make the payment to him, and he will be allowed to go. So if he does not give a public notice, then there are two consequences. One, he will be admitted into the partnership by default. The second thing is he will be held liable for holding out as far as the other parties are concerned. So in his interest and in the firm's interest, they have to there has to be a notice about his choice, and that notice has to be published in accordance with section 72. So in this section 72, there are two types of public note. There are two variants for public notice. One, for registered firm, what is the procedure, and unregistered firm, what is the procedure. For a registered firm, the procedure is there has to be a notice given to the registrar. The second thing that has to be done is a notice has to be put in the official gazette. It has to be notified in the official gazette. Then the third thing is an advertisement has to be given in a notice has to be given in a vernacular newspaper operating in the district where the place of the business of the firm is located. So a registered firm, all the three modes have to be used. In case of an unregistered firm, anyhow they are not registered, so you don't have to intimate the registrar. However, you have to give a notice in the official gazette. Then you have to give a notice in a vernacular newspaper operating in the district where it is, where the place of business is of the firm is located. So only when this kind of a notice is given will the requirements of public notice be fulfilled. So this is a very elaborate chapter, and implied authority, then holding out, and minor related provisions, they are very important. Thank you.